Hello everyone, welcome back to my channel. Today, I want to discuss a very important Supreme Court judgment that affects thousands of flat buyers across India. This case answers a question many home buyers ask when projects are delayed or builders go bankrupt. If builders, if the builder company fails, can we recover our money from the directors or promoters personally? The Supreme Court has now given a very clear, detailed answer to this question. Let us understand this slowly, step by step, in simple language, without any legal jargons. This case is called Ansal Crown Heights Flat Buyers Association versus Ansal Crown Infrabuild Pvt. Limited. Here is what happened. A group of home buyers or flat buyers booked apartments in a project called Ansal Crown Heights. The builder company promised to hand over possession within 36 months. That deadline expired in 2013 and 2015. But the flats were never delivered. So the flat buyers went to National Consumer Commission asking for the possession with interest or refund of money with interest. The Consumer Commission passed an order in favor of the buyers. So far, everything looks very normal. Now comes the real problem. The buyer company did not comply with the order. Meanwhile, the company entered into insolvency proceedings under the Insolvency and Bankruptcy Code or IBC. Because of insolvency, a moratorium came into force. This meant buyers could not recover the money from the company's assets. So buyers tried something else. They said, if the company cannot pay, let us proceed against the directors and promoters personally. This is where the legal fight began. The core question before the Supreme Court was, can an order passed only against a company be executed against the directors or promoters personally? Especially when directors were not parties to the case. No findings were made against them. The answer to this question was huge consequences for flat buyers, builders, company directors, insolvency law regime. The Supreme Court had come up with a very recent order. The Supreme Court said something is very important. Let's simplify it. The first principle, a company is a separate legal person, means a company is a one person and directors are different persons. Just because someone is a director does not automatically make them personally liable. Second principle, execution must strictly follow the original order. If the Consumer Commission's order was passed only against the company, then execution cannot be expanded later to include directors. And the third principle, what Supreme Court said that directors were not issued notice, no pleadings were filed against them, no evidence was recorded, no findings of the personal liability was given, so there was no legal foundation to recover the money from them personally. And the fourth principle, the Supreme Court clearly said execution proceedings cannot be used as a shortcut to fix the liability on people who were never tried or heard. This would violate basic principles of natural justice. And there is an important clarification on the insolvency too. Now many people get confused here. Earlier Supreme Court said moratorium under the IBC protects only the company, not the directors. That is true. But the court clarified something very crucial. Just because moratorium does not protect the directors, it does not mean that directors are automatically liable. They can be proceeded against only if there is an independent legal basis and there is a separate finding or liability or a guarantee or a fraud is established. None of this that existed in this case. So the execution failed. The Supreme Court dismissed the flat buyers' appeals and held that the Consumer Commission order is executable only against the company. Directors and promoters cannot be forced to pay personally in execution. However, this court also gave an important relief. It said that buyers are free to take other legal remedies if available. For example, proceedings under the Companies Act, fraud or misrepresentation cases, properly framed civil suits, etc. So what is the lesson from this judgment? If you want to hold directors personally liable, you must do it at the adjudication stage, not at the execution stage. This judgment is a wake-up call for home buyers, lawyers, consumer forums, and the legal strategy finally matters. If you found these explanations very useful, kindly subscribe to my channel. I will see you in the next video. Thank you very much.